Hi, everyone. Good afternoon. My name is Melody. I'll be picking up the baton from Manny. Sorry, there's no break here, truly no break for the eager. And I hope it doesn't feel unfair that I've upset your expectations there. But just to introduce myself a little, I am a 3L at Yale Law School, have been focused on antitrust and regulation and worked at the antitrust division of the Department of Justice last summer. And I'll be going there again after graduation in the transportation, energy, and agriculture section. So I'm delighted to present to you a panel on intellectual properties, contracts, and data. And so our panelists will be taking us through a walk through the legal doctrine and chart out some pitfalls and some hopeful paths, and also explore how new technologies may exacerbate problems that we've heard described to us earlier during this conference. So we have Matt Summers, who is at Harvard Law School, and he'll be presenting on the right to repair and how we should think about aftermarket monopolization. We also have Molly Collett, who is a student at NYU Law School, who'll be talking about seed patents in the wake of Qualcomm. And finally, we have Professor Salil Mehra, who is a professor of law at Temple University School of Law, and his research focuses on antitrust and technology. And at this conference, he'll be presenting on data accentuated monopsony and kind of charting out this emerging area. So, at this point, you guys know the drill. If you have questions, feel free to chat them to me. And you should also feel free to raise your virtual hand once folks are done presenting. So with that, let me turn it over to Matt to begin his presentation.
Hi, thank you so much, Melody. Can you hear me? It seems like you're only in one AirPod. Great. So ironically, given the potential technology error I'm experiencing right now, I'm going to talk to you about the right to repair. So if you live in Massachusetts, it's likely that you voted on this issue in the most recent election. And if you live in any number of dozen or two states, the right to repair has likely come up in your state house or on ballot initiatives in the last few years. So for those of you that have no idea what I'm talking about right now, the right to repair is, in the most basic form, the ability to repair the things that you own and not be punished for that. So what does it mean to be able to repair your stuff? That means that if your iPhone, for example, or your car breaks down and you want to jump in there under the hood or behind the glass and fix parts of it, it means that you'll have access to the materials that you need to be able to do that. So those are things like replacement parts. And it also means that your warranty won't be voided for you doing that. So you have the right to basically manage the things that you own in whatever way you want to. And this is pretty important for a lot of people, and it's especially important in the agriculture industry. And so what I'm going to talk about today is I'm going to run through a few important things. I'm going to talk to you about why this relates to agriculture first. Then I'm going to talk to you about a 1992 Supreme Court case that will hopefully not make you fall asleep. That's really important for the right to repair and remains important for advocates today. And then lastly, and most importantly, I'm going to talk to you about the economics and the application to the agricultural sector, specifically focusing on tractors. And I'm going to try to not run over my 5 minutes. So the first thing I want to jump into is why this relates to the agriculture industry. And to contextualize this, first I want to give a shout out to Claire Kellaway, who's on the call, whose research I rely on a bunch. The first thing about this is that if you have a tractor, let's say, and you're going through harvest season, you might only have a few days or maybe a week or two to be able to get the most value out of your fields. And if your tractor breaks down and you don't have the right to repair it yourself, and you don't even have the right to get an independent repair shop to take care of it for you, then it could mean that you're waiting for days or weeks for the authorized repairers to get out to where you are and help you fix your tractor or other agricultural equipment and get the valuable product out of the fields, which is where you need to get it from. So specifically, farmers and folks in the agricultural sector have had a huge issue in recent years because John Deere and other related companies are able to basically lock people out of repairing their own devices. And if you're locked out of being able to repair, that means that you, again, either lose your crops or you just spend a tremendous amount of money. And that's where the antitrust angle comes in. So for the antitrust folks that were waiting for their cue, that's sort of where I come to this work, is the notion that there's a special kit for these repairs and for the replacement parts. And if one company is able to dominate that, it's able to raise prices, damage consumer welfare, and whatever other metrics you care about most. And it means that people are ultimately, like, consumers and the small businesses, small farmers, are harmed. So that brings us into this Supreme Court decision from 1992 called Eastman Kodak. And Eastman Kodak was, in my opinion and the opinion of a number of other people, a fairly radical decision by modern antitrust standards. It said that there was a specific definable antitrust market in the aftermarket for one brand of products. So for those of you that are not steeped in market definition, this is important because a lot of the time when you think about a market for a particular good or class of goods, you're focused on a number of companies that are competing to fight for consumers in that market. And so limiting to one brand to make a market is already a big deal. And limiting to not just one brand, but one product, and not even the product itself, but the aftermarket for that product, is an even bigger deal, because the more narrowly you can define that antitrust market, the more likely the court or courts are to find that the company has market power and is taking advantage of that market power. So what Kodak looked at was Kodak was producing these basically large copiers. And these really large copiers were things that companies were investing a decent amount of money in upfront. They were paying a lot to get the copiers. And once they had them, they wanted to get them repaired. And so a huge crop of independent service organizations rose up to be able to meet that demand. And not only were they able to repair these devices, but they were able to repair it better and more cheaply than Kodak was. So Kodak was not too thrilled about this, because they wanted to monopolize the aftermarket for repairs of their own devices, because it's great to be able to charge monopoly rents to the people that want to repair their multi-thousand-dollar copiers. So Kodak decided that, hey, we have all of the spare parts. We're the only ones producing spare parts for Kodak equipment. And so we're going to stop selling these replacement parts to the independent servicers. And the independent servicers were like, this seems bad. And Kodak was like, this seems great, because we're able to charge monopoly rents. And the Supreme Court agreed with the independent service operators that this might not be great. And you could define a specific market for the aftermarket of Kodak copiers. And then it sent it back to the lower courts to tussle it out and figure out whether or not there was actually anti-competitive harm going on. So in the last few decades, however, basically no one has been able to be successful using a theory that's similar to the independent service operators in Kodak, which is a huge problem if you are a farmer who is not able to repair your tractor and is basically suffering from any kind of a monopolized aftermarket. Cars are a weird example here, because there is some specific statutory law that makes it easier for you to go to independent repairers. But if you know anything about what Apple's done in recent years, it's made it a lot harder to independently repair your devices and avoid voiding warranties and things like that. So to breeze through the relevant economics here, on a high level, it's important to understand the economics of these aftermarkets, because that's what antitrust courts are using to evaluate them. And so I was going to dive into why each of those 10 factors are relevant to the tractor market specifically, but instead I'll let you read my paper / address it in the questions and just run through the 10 economic factors that are relevant. First one is if there's really high switching costs. So if you spend nearly $1 million on a tractor, it's really hard to switch to another one. So they can raise the prices on you in the aftermarket without you having a lot of recourse. The second is complete contracting. So if you're able to write contracts that specify how much it'll cost to repair your device over a long period of time. The third relevant factor is whether or not you're able to do life cycle pricing, which means that you can know how much it's going to cost you, which was a huge debate in the Kodak majority and Scalia's dissent about whether or not people were projecting far enough out how much it was going to cost to repair their device. Fourth, whether there's enough data to do that kind of pricing at all. Fifth, whether how profitable the aftermarket is, because if it's really profitable in the aftermarket and not so profitable in the foremarket, you might be able to squeeze consumers in the aftermarket. Sixth, the number of consumers that are locked into your products. If you've spent any time thinking about Amazon or Facebook in recent years, you probably also have thought a lot about lock-in. Seventh is the question of weak competition in the foremarket. So if John Deere dominates the tractor foremarket, that could be a problem. Eighth is whether it's like heterogeneous in the relevant industries. Ninth, whether the tractor or relevant company operates across multiple markets. And 10th is if there are low discount rates. So anyway, I'll kick it back to the other presenters, and thanks for listening.
Great, Molly, you have the floor. Thanks, Matt.
Well, I have some slides, so I'm just gonna try and share them. Okay, can you guys see the slides?
Yep.
Cool. All right, good afternoon, everyone, or good evening or good morning, depending on where you are. I just want to quickly say thank you to Yale Law School and the Thurman Arnold Project for hosting this event, and to everyone who's tuning in. This is my first conference, so I'm really excited to talk to you about seeds and patent law. Okay, so come mid-August, American consumers can purchase ears of corn from innumerable locations, from suburban Costco's to Ohio grain elevators to farm stands and CSAs. While the corn is grown and distributed in geographically diverse locales, on a cellular level, each ear of corn likely comes from just one of three places. Seeds developed by Bayer, formerly Monsanto, Corteva, and ChemChina, which is also known as Syngenta. The seeds developed by these three firms together account for more than 82% of all corn grown on 91.7 million acres of American cornfield. And with such a significant share of the market, these companies have a veritable oligopoly on corn seed, a kind of shared monopoly that dovetails with something else in the company's possession: utility patents. Although seed patenting and seed company consolidation have come to define the industry, both are relatively recent developments and mark a drastic shift from the origin story of seed in US agriculture. Initially considered a public good, in the 19th and 20th centuries, seed research and development was primarily the domain of individual farmers who would save seeds and breed crops, as well as the government, which had a vested interest in developing and distributing high quality seeds to farmers. However, the mid-20th century brought about increasing privatization of the seed industry, which was catalyzed by changes in patent laws beginning in the 1970s, with the advent of the Plant Variety Protection Act of 1970. This act permitted seed companies to obtain PVP certificates, which is a class of patent for seeds and sexually reproduced plants, but these certificates were limited in the scope of their IP protection. The most significant of the watershed changes to patent law affecting the seed industry was a Supreme Court ruling in Diamond v. Chakrabarty in 1980 that permitted a utility patent to be granted for the first time to a living organism. And this historic ruling paved the way for seed companies to file for IP protection under the much more rigorous utility patent. So in the last few decades, the public interest that the government had held in developing a robust seed program has become the distinctly private interest of a biotech seed industry that's incentivized to invest in R&D and then reap its benefits in the form of licensing fees. And it is perhaps intuitive that such a development of intellectual property rights, which I'm going to refer to as IPR, with respect to the American seed industry would coincide with that industry's consolidation. IPR has a somewhat of an insulating effect on monopolistic business practices, as it grants a temporary monopoly on a proprietary invention, allowing the owner to essentially charge whatever the market will bear. And to understand the contemporary tension that exists between IPR and antitrust regulation, a recent Ninth Circuit ruling in FTC versus Qualcomm is illuminating. For my research paper, I was particularly interested in this case because the defendant, Qualcomm, holds both patents and monopoly power, just like the three dominant seed firms. And while Qualcomm dealt with anti-competitive business practices in the software industry, this ruling, which found that the FTC did not meet its burden under the Sherman Act rule of reason, has implications for antitrust regulation in the American seed industry. In my paper, I looked at three implications of the Qualcomm ruling on the US seed industry, and I'm going to briefly cover those implications now. Perhaps most significantly, the circuit court in Qualcomm ruled that the defendant's no license, no chips policy did not violate federal antitrust laws. In permitting this kind of bundling, wherein Qualcomm used their monopoly power and patent protected chips to increase the price for their non-exclusive licenses, the Ninth Circuit has given a green light to similar practices in the agricultural industry. So bundling and cross-product licensing are already common practices in the biotech seed industry, with companies stacking discrete traits within single seed products, and then relying on patent licensing agreements to trade licenses with other companies. However, this ruling could grant more leeway to patent holders by allowing seed companies with exclusive patents to bundle those patents with other licenses and effectively create a tax on rivals' products. It's particularly unsettling given the increasing vertical integration in the agricultural industry, which a couple of the other panelists discussed earlier. In addition to bundling traits within seed products, a company like Bayer could, for example, instigate a no chemicals, no kernels policy, leveraging its patent protected seed power to compel farmers to also purchase any of its agrochemicals in tandem, and thus leading to further vertical market consolidation. Another key holding of Qualcomm relates to a monopolist's duty to deal so as to not suppress its competition. The district court in that case found that Qualcomm's refusal to license to its competitors at the chip level violated an antitrust duty to deal with rivals. However, the Ninth Circuit reversed on this issue, finding instead that because Qualcomm had a legitimate business interest in only dealing further down the supply chain, in order to avoid the doctrine of patent exhaustion, Qualcomm was not obligated to license to its rivals. And here the Ninth Circuit prioritized Qualcomm's protection of its IP rights over excluding an entire sector of competitors from the market. And there's a similar analogy actually in the agricultural industry. So in the biotech seed industry, it's not a rejection of the duty to deal that has stifled competition, but rather dealing subject to terms and conditions permitted by patent law. So seed companies are happy to license their proprietary seeds, but it's the restrictive covenants attached to such licensing that has eliminated an important source of competition from the field, and that's the farmers themselves. Utility patents for seeds prevent farmers from replanting the seeds generated from that plant's life cycle in subsequent seasons. So in effect, it precludes farmers from saving their seeds and reusing them. Instead forcing farmers to purchase year on year from the seed companies. And the effect is that farmers are excluded wholesale as an independent source of seed supply, reducing competition for the large seed firms. And finally, this ruling exposes the challenges the FTC might face should the commission pursue antitrust action against the three oligopolistic seed firms. That was a mouthful. The Ninth Circuit's rejection of the FTC's antitrust claims may actually suggest that for plaintiffs seeking remedies against the unfair business practices of Bayer, Corteva, and ChemChina, contract or patent law may actually prove more viable than antitrust law. Moreover, private suits, so suits brought by farmers or consumers, as opposed to the commission, may be more effective in shaping corporate behavior. Because should such suits be successful, the defendant is subject to triple damages, which is not available in suits brought by the FTC. The prospect of triple damages would likely create a more powerful disincentive to engage in harmful business practices. Nonetheless, should the FTC choose to pursue an antitrust case against Bayer, Corteva, or ChemChina, they may find it prudent to avoid filing in the Ninth Circuit under this new Qualcomm precedent. Overall, the Qualcomm ruling has condoned anti-competitive business practices over antitrust concerns. The ruling illustrates the synergy between intellectual property rights and monopolistic business practices that has existed in the seed industry since utility patents were first granted for plants in the 1980s. While this may benefit conglomerate seed companies, the consolidation that has been permitted by intellectual property rights is otherwise detrimental in that it stifles innovation, leads to monocultural agriculture, and is ultimately more costly for farmers. Seeds form the root of all US agriculture. Developments in patent law from 1970s Plant Variety Protection Act to this most recent Qualcomm ruling have catalyzed a series of transitions within the American seed supply, from a public good to a private industry to an oligopoly controlled largely by 3 multinational firms. The prioritization of IPR over such increasing consolidation and its attendant antitrust concerns has implications not only for mid-August corn available to American consumers, but also for the sustainability and future of the agricultural system in its entirety. Thanks.
Great, thanks so much, Molly. Professor Mehra, you have the floor.
Okay, thank you. Can you hear me okay?
Yep.
Okay, great. I'm going to share my screen then. Did that work? Thank you. All right, so first of all, I just want to thank the folks at both Thurman Arnold Project and LEAP for inviting me. It's actually wonderful to see law students interested in antitrust. It was only a little over a decade ago that Richard Posner could joke that antitrust was dead. And I think that you found a great topic at the intersection of this sort of new moment in antitrust interest, as well as the interest in the US food system and some of the changes we've seen. I've learned a lot today. I've been here since 9:15. You've had some great speakers. My title comes from Chris Leonard's word, chickenization, which obviously extends beyond chicken. And in particular, I'm concerned about what I consider data-monopsony, or the intersection of monopsony power and data and vertical agreements. I'm not a person with special knowledge of agriculture. I started my career as an antitrust lawyer, and I've been teaching antitrust law for a couple of decades now, starting at the DOJ. So Melody, good luck. But at any rate, I start from this phenomenon that Chris Leonard wrote about, earlier in the decade, intermediary concentration, right? And particular attention has been paid all day to, in the chicken industry, in the pork industry, in the beef industry, where we had transitions from many small players. Now 4 firms control over 80% of beef, 4 firms control over 85% of pork, 5 firms over 60% of chicken. These are all intermediaries, right? They're processors. Agricultural people seem to call them processors or meat packers, but antitrust lawyers would probably call them intermediaries. Traditionally, these are sort of difficult cases for an antitrust lawyer because there's usually the logic that even if intermediaries have high share, the end buyer, maybe that's Walmart, or a powerful buyer, maybe that's Walmart, can try to go around them or can integrate into the space, or a powerful producer can do it. But one of the things I think that's really important is to recognize that what Leonard calls chickenization involves not just intermediary concentration, but vertical integration, right, through contract or investment or restraints of various kinds, which creates a level of control that prevents going around the intermediaries easily, I think. And that's where I start. I know chickenization has all kinds of other connotations in terms of harm to small producers and impacts on agricultural communities, but I'm primarily concerned from an antitrust lens. I'm not that the other things aren't important, but these ideas of intermediary concentration and tight vertical integration through contract. And so one of the things we might worry about when we see this is that we might see the exercise of monopsony power, which is essentially the inverse of monopoly power. And just very briefly, right, a monopolist, the harm of a monopolist is that they can restrict output and cause prices to go up. So a monopolist can choose to sell less and prices will go up. Because they are a monopolist, there is nobody else. No one else can come in and undercut them, right? The inverse is a monopsonist who can choose to restrict how much they purchase, causing prices or wages to go down. Because there's a monopsonist, there isn't anyone else. They don't have to worry about being overbid, right? So, this is potentially bad, right? Because it leads to all kinds of the similar harms as monopoly, right? You get less innovation, maybe less variety, allocative efficiency losses, which is a technical word, right? But there are people who have argued that, well, if consumer prices are going down, who cares, right? Isn't antitrust just about consumer prices? Famously, an FTC commissioner, Tom Ross, argued that in about 2006. And that might have been a good argument, except that over the past decade in this space, we've seen prices go up, and this is even before COVID, in chicken, beef, pork. Now, obviously, if you're going to be technical about it, an economist want to know, well, are there other changes, right? Like, is there a tremendous increase in demand worldwide for these things, or are there droughts, like supply shocks, things like that? But it's no longer easy to just say, oh, well, we've seen this incredible concentration, but they're bringing costs down, so therefore consumers paying less for chicken or pork or beef or other things, right? Additionally, I would point to this string, especially recently, of antitrust litigation. And it's not clear where all of this will lead, right? But we see DOJ indictments against the chicken industry. There's a publicly announced investigation of beef. The AgriStat cases, there's a few of them actually are really interesting, are the cases that refer to them. So one in the pork industry, arguing that they're supplying essentially detailed information to each other, different processors. There's one in the poultry industry in Maryland, actually, which is actually by it's a class action of employees, also arguing about the use of data sharing, sort of through AgriStat between the processors, that they're giving information to each other about their purchases, their prices, et cetera. There's an interesting case, it's been dismissed, but could be refiled in Minnesota with the beef processing industry, arguing that they basically contract into having their suppliers use a very stylized way of bidding that leads to essentially an option to buy beef as opposed to actually buying beef, and in which what information they can disclose if a producer gets a bid is limited. The reason I bring these up is because typically when we think of a monopsony, we think of one buyer, but you could also have collusion, right? You could have, whether it's maybe by geography or maybe by interaction between the parties. I've written elsewhere, other people have written about this too, about the possibility of algorithmic collusion, which is the idea that technology and increased data can allow firms to better predict each other's responses, even without an agreement, and lead to higher pricing. I think it's an interesting question what we're going to find out from this series of litigations. And in part because, for example, one of the arguments in the pork AgriStat case that the defendants have made is that we're sharing data with each other that's a couple of weeks old, so it's not current immediate data. But arguably, you could use that to train a model or computer program or algorithm to better predict responses of your competitors in a way that would lead to higher prices. There's a bunch of work on that. There's an interesting, if anyone's interested in that, there's a brief sort of paper in the American Academy of Sciences sort of public-facing journal by Calvano and Joe Harrington, some other people. But it's possible that that's something that could happen. I'm not saying it for sure will happen, but I think this is something antitrust people need to think about and look at in this industry. Additionally, what I point to in this paper is that normally when we have a seller, like a producer of a farm product, and a buyer, like the intermediaries or processors here, there's a sort of asymmetry in knowledge in the contract, right? People who know what they're selling know more about it than the people who are buying. Now you can you can deal with that by contract, you can deal with that with warranties and things like that. What I would argue is, to the extent that this provides any sort of comfort to processors right now, it could be going away. Some of the technologies like smart farming and the Internet of Things will allow even greater vertical control in the sense of real-time data that allows for even further stronger control of the producers by the intermediaries. So if there's already a lot of power, it might actually be exacerbated. So just to sum up, my prescriptions at this point, because this is a little tentative, as you can see, that a lot of the litigation in this area is just from maybe the last 24 months. I think we need to reconsider, and this is already going on in some other areas, how benign vertical restraints are in this area. Unfortunately, the Chicago School taught us that vertical restraints need not necessarily be terrible, but for federal courts, some of them seem to have taken the lesson that vertical restraints are a-okay, and that is not true and should not be the law, right? The second thing I think we need to think about is, especially as we go forward with technological change, we need to think about how tolerable concentration levels are, whether that's for merger policy or what have you. A lot of the consolidation happened during a period where we were told, as long as we have 3, 4, 5 firms, we'll be perfectly fine, and Walmart's a power buyer and can control this, it'll all be great. And that might not be true anymore. And at that, I'd like to turn it back to the group.
Great, thanks so much.